Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guests.
Today we are starting a series of programs on the Idaho Free Exercise of Religion Act. In this state, as well as a number of other states, laws have been passed recently that deal with this issue as it pertains to using religious beliefs to engage in certain activities, and the state must have a essential compelling interest to prevent those activities if it is done in the name of religion. On these programs, we will have some individuals that are in support of this legislation and some who oppose this legislation. On our program today and next week, we have an attorney who is in opposition to this law that went into effect on February the 1st, year 2001. Our guest is Norman Gissel. He is an attorney in the state of Idaho and has practiced in this state for many years and is best known recently for his successful representation along with the Southern Poverty Law Center and Ken Howard of the Aryan Nations versus the Keenans. And he and the other attorneys I have mentioned represent the Keenans that were successful in that lawsuit. Norm Gissel, welcome to our program. We've had you here a number of times before, and thank you for coming and being with us these 2 weeks to discuss this particular piece of legislation.
I appreciate being here. This is an important subject, and I'm grateful for the opportunity that you've allowed both sides, proponents and opponents of this law, to be here.
Thank you so much. In later programs, the other side will be here. I also welcome to the program our two regular panelists, Janelle Burke, an attorney in the state of Idaho, and next to her is Steve Schenck, who is the Vice President of College Relations and Development with Idaho College, and we shall ask Janelle to commence today's questioning.
Norm, this act is entitled Free Exercise of Religion, and that sounds pretty good, but is it really as good as it sounds?
Well, like in every statute, you have to examine the details of the statute before you can assign good or bad to a particular statute, and in my own mind, I see nothing but problems for the Idaho citizens as this act becomes better known, as it starts moving through the judicial process.
And what was the background? What led to enacting something like this?
As I understand, there was a case, a U.S. Supreme Court case called the Smith case, came out of Oregon, was settled by the United States Supreme Court in 1991, and there was language in that disturbed the religious advocates in the United States, people that spend a lot of time in furthering of religious causes throughout the United States, were upset about this particular ruling. I'm not quite clear because I don't think that there's anything in that case that would cause anybody to be alarmed, but nevertheless they were. And that caused the United States to pass the RFRA case, the RFRA law, which was the National Freedom of Religion Act, and then that got defeated in 1997, so there's no longer a national law based upon the Idaho case is based upon the national case. The national case was ruled unconstitutional in 1997, and then states throughout the country, I believe there's 9 now, including Illinois, Texas, Florida, Alabama, I believe is one, and in Idaho. And so the setting that was precipitated by the Smith case, and then it went to the federal level, and now it's down to the state levels.
You referred, as you were talking to the RFRA, and you referred to that as a case. I believe you're talking about it's a statute, it's an act. Isn't that correct?
Oh, yeah, RFRA, yes. There was a national RFRA.
Yeah, a national act, and now we have the Idaho Act, which is statutory law.
Right, statutory law, yes.
Well, there's a lot that confuses me about this issue, and I'm here in the studio today with 2 lawyers and a political scientist and feel ill-prepared to discuss it. So let me try to boil things down to a language I can understand. And I've read the law recently, briefly. It's not terribly explicit. What does it say, and what does it mean to the average person or to a church?
Okay, and I'm most comfortable, actually, because we don't know because it's not been litigated in Idaho and has only become a law in Idaho since February the 1st, and we're here on the 21st, it's been a law for 20 days. I do think I know how it affects the ordinary citizen. What this law does is it invests in religious people in the state of Idaho new powerful rights that they did not previously have, and that these rights are kept from people who are not religious in the state of Idaho. So the effect of this law is, by force of law, the state legislature in the state of Idaho has created two classes of people: a religious class of people versus, and it is versus, a class of people who are religious but would never dream of assigning a religious motive to any of their conduct, or certainly would not tell the government that some of their conduct under question was religiously motivated, because it is not the government's business what your religion is. And, of course, atheists and agnostics, and, ironically, business corporations who have certain rights throughout that wind their way throughout Idaho law, but business corporations, by definition, are for-profit corporations and therefore cannot be ascribed a religious motive for any of their conduct. So all the benefits that are conferred upon this new powerful class of citizens is not given to business corporations.
Interesting. If I can follow up quickly, Norm. Since freedom of religion is protected in the U.S. Constitution, I have to guess that this Idaho statute was written and approved and signed into law to fix something. What needed fixing? What additional protections did the Idaho legislature feel were necessary that aren't existent?
That's a legitimate question, and I've searched for the answer to that myself, and I'm going to tell you that I don't have an answer for that. Idaho is a very religious state. We have a large contingent of Latter-day Saints and a large Catholic presence, and we have all of the traditional denominations of churches in Idaho that are throughout the United States, Lutherans and various Protestant denominations. These churches and their constituents seem to be thriving in the state of Idaho and are in not need. And I would make the argument, and maybe we'll get a chance to make it, that religion, almost by definition, does not need legislative protection and does not need legislative condemnation. Religion thrives on its own as a unique, almost like business, like free enterprise that thrives on its own. It is not something that needs governmental enhancement. I don't think you can find anywhere in any scripture throughout the world, and in almost any religious denomination, that requires legislative assistance for its existence. I just don't think that people that write the Bible or that write the Torah or these other religious documents have ever written in there that government must come to their assistance from time to time. And that's what's happened here, is that government has come to the assistance of a particular class of people, and they have not come to the assistance of the rest of us. So to answer the why question, I think this is a legislation that was passed without a present need for it. If government ever needs, quote unquote, to come to the rescue of a religion.
Thank you.
I'd like to quote from the code itself, Norman, addressing this. As you read, it's very brief. I mean, it's not a long section of the code, but it says in the code that government shall not substantially burden a person's exercise of religion. And it does have some exceptions, but those are very strong language, and I'll get you to respond to this. It says government may substantially burden a person's exercise of religion only if it demonstrates that application of the burden to the person is both, and this seems to be key language, A, essential to further a compelling governmental interest, and B, the least restrictive means of furthering that compelling governmental interest. It seems to me that's very strong language, that the government has a tremendous burden to prevent behavior if it's done in the name of any religion. And then it goes on to say that if the individual who is in court, if there's litigation, and if the person prevails in court who is exercising a religion against what the state may think is a state compelling interest, that the individual, the party that wins, receives attorney's fees and so forth. So this is kind of an elaborate
attorney's fees
question.
and cost, yes.
And cost and attorney's fees. So would you say that there's, from your perspective, trouble with that it's essential to further a compelling governmental interest, and that's the most or the least restrictive means of furthering that state interest?
That's in the law, and I've practiced law for 30 years, and this is incontestably the strongest language that you can give to a litigant in the state of Idaho when he or she is contesting a piece of legislation that she or she thinks is unconstitutional or just goes against his or her interest. Everybody in the state of Idaho prior to June or February the 1st of this year, when they contested a statute and they were angry about what the government was doing in planning and zoning or some other law, usually, except in rare instances, the test that was used against them is the rational basis test. And the judge would look at the law and says, is there a rational basis for its existence? And if there is, then it's applicable in the given situation. And we've lived with that rational basis test for the time that Idaho became a state and for the time that the federal government became the federal government in 1789. We have dealt with that, and we have created one of the greatest nations that the world's ever seen. And we have lived under that, and we're all equal under that. I still live under that. If I refuse to proclaim a religious purpose for any act that I may take or any action that I may have, but for a religious person, they have this new enhanced set of rights. When I go in planning and zoning, and something happens that I don't like, and I contest it in the court of law, I may win, and I will have the satisfaction of having won, and I'll get my way in the Planning and Zoning Commission, but I'll have to pay my own attorney's fees. And I will have to have proved that the planning and zoning law as it was applied was irrational. Now, if a person goes in and contests a planning and zoning ruling, the standard for this new enhanced newly powerful person is that the government must show that the law that they're attempting to enforce has a compelling state interest behind that statute, and that the least restrictive means of furthering that compelling, and that the law itself is the least restrictive means of furthering that compelling state interest. And if the government is wrong, it pays the attorney's fees and costs of suit to the religious person who has brought this lawsuit.
But
it's quite incredible.
Since you're not going for a religious purpose, then you could never get, even if you win, you can't get court costs then.
Yeah, on almost every instance, that's true. I mean, that's incredibly destabilizing to society when you have two sets of classes of people. It's almost unheard of. You have to go back to the Jim Crow laws in the South, where there were separate fountains for two sets of Americans, black Americans and white Americans. And there was the black Americans couldn't vote because they couldn't get an education and they couldn't read. You have to go back to those times to find an equivalent set of laws or a body of laws that even approached this situation. And so that it's profound, and it moves at every level of government: the state government, the county governments, city governments, the schools. Schools are specifically mentioned in here. And any commission, any board, at any level of government will have a brand new threshold that they will have to deal with to when they're presented with a religious purpose for any activity. And I want to go in and I want to spend some time talking about the breadth of this law. It moves into the criminal justice system. Never in the history of the state of Idaho has a criminal defendant, I mean, I just can't think of a single case where a criminal defendant has been accused of a major felony or even a minor felony, a felony, and was prosecuted. That was when, if he was successful in front of a jury, was awarded attorney's fees and costs of suit. I don't believe that ever existed. Now it exists, and it exists only for religious people. So if a person is hailed into court and he believes, or his attorney has a conversation with him, which they certainly all will, what motivated you to do this conduct, if you did it at all? You always have the defense that you didn't do it, but if you did it, and you had a religious basis for it, you may be able to go in front of a jury, win your case on that basis, and be awarded attorney's fees and costs of suit. And that comes from the taxpayers of the state of Idaho. These are all unbudgeted amounts that'll be shelled out at different times. We've never had a situation like that, so we don't know what the effect of it will be. It'll be fascinating to work through this process and see how this two classes of citizenship thing will sit with the Idaho people. It's my feeling with the Idaho people that they're not going to like this one little bit. It's always been a cultural assumption of the state of Idaho that we're all equal. There isn't anything inherently wrong with us all being equal in front of the bar of justice. Mormon bishops, Catholic priests, ordinary citizens, they're all equal in the eyes of the law, and that's as it should be until now. And we have a brand new theater in which to operate, and brand new sets of rules. One of the interesting situations that's come up, and it is partly based on that Smith case too. In 1991, the state of Idaho passed a law that allowed a certain group of religious people in the state of Idaho to consume peyote. Peyote is a hallucinogenic, and peyote is a Class 1 controlled substance. And for the viewing audience, a Class 1 controlled substance, there's 3 classes of controlled substances, and they're all dangerous drugs. They're hallucinogenics or the habitual type of drugs, so they're all dangerous to society. And so there's over 100 Class 1 drugs, and they include marijuana, a form of LSD, amphetamines, psilocybin, and a variety of other drugs of that nature. The 1991 legislature in the state of Idaho said that it is criminal for anybody, it's a felony for anybody to consume peyote except for one particular religious group. And for that religious group, it is not a crime. So you have this bizarre situation from 1991 until to February 1st of this year. You had this bizarre situation where somebody could take peyote frequently in the pursuit of a religious experience over here and do it 3 times in a row and be regarded as highly spiritual, while his neighbor could take peyote 3 times in a row, be arrested 3 times in a row, and be sent to jail for life for being a habitual criminal.
Let me just interrupt and say one thing and go back to Janelle. So with this law now and going into effect February 1st, 2001, it broadens this process to where are you reading the law to say that other people could create a religious belief system or already have one, that they could use marijuana or LSD and so forth, and if they use it in a religious context, that they would be protected by this law, but if you did it for non-religious purposes, you could be prosecuted?
I don't know. This is a 20-day-old law, and I don't know how it'll manifest itself ultimately in the court system. But that, I can guarantee you, is an argument that's going to be made and made vigorously.
So someone would attempt to have a church, the Church of Marijuana or the Church of LSD.
Yeah. I think it's a form. I think LSD itself is a Class 3 drug, but I think there's a form of LSD that is a Class 1 drug. But psilocybin, and marijuana is excellent. Or
but anything that comes
amphetamines.
in class 1, you could
could
attempt to use
yes,
that as
yeah.
a religious belief.
Absolutely. I mean, if logic says that the state of Idaho cedes its duties to guard Idaho citizens from the use of harmful drugs through the Controlled Substances Act, if they make a religious exception to that of one type of class 1 drug, arguably, and if logic still operates in the state of Idaho, we'll have to see, but logically then, any class 1 drug then would be susceptible to this religious process, because the state legislature, in my mind, has taken all religions and has placed them on the level of the religion that can use legally peyote through this process. So I think that there's going to be a huge amount of litigation over this subject, and that'll be reach the Court of Appeals. I don't know. I suppose 2 or 3 years.
Janelle Burke.
I want to just go back to the act itself and kind of clarify here what's happening. Normally, with the constitutional issues of religion, we have 2 prongs, if you will. One deals with establishment of religion, and
Right.
one deals with freedom of exercise of
Right.
religion. And this specific statute deals with the exercise of religion, meaning in how a person goes about practicing their religion. Is that how you would see it? That's what this is basically dealing with, how
Right.
a person practices.
Right. And what this law does is that, for the most part, and this is not entirely true in all instances, but for the most part, the government cannot establish a religion or advance all religions. In fact, the Edwards case in 1944 said that it's obvious that the First Amendment prevents the enhancement of all religions, which essentially this case does, absolutely. But there's 2 sides to the issue. There's, as you pointed out, there's the establishment side, and then there's the exercise side. For the most part, the laws as they developed in the United States and the laws as they developed in Idaho and all of the states is that when a law of general applicability incidentally affects a religious activity, since it is a law of general applicability, then the religious body has to accept the reality of that law and conform their conduct to this law of general applicability. And when we get into trouble when we pick out particular religions and start making exceptions to the laws of general applicability, as we did in 1991, because what happens is it destabilizes the very foundations of democracy, which are essentially, in my own mind, based on equality, based on the rule of law, and based on the concepts of freedom. So you have freedom, equality, and the rule of law as kind of a triumvirate that is the basis of democracy. And when you accept out in the rule of law and you say that I will enforce this law against these people, but I will not enforce the law against these people. I will send these people to jail. I will not send these people to jail. I will exalt them for their religious qualities, but I will send these people to jail. When you have that, what you've done is you have destabilized your society because it's no longer equal. It doesn't have even a fiction of equality. It doesn't exist anymore.
Now, in the practice, so people are practicing religion. In the past, most often, if the practice ran afoul of certain laws, in other words, you could only practice your religion to a certain extent.
Right.
You were not free to do it completely any way you just wanted.
Right.
But when this law is applied, then it means that the government has to come forward to show a heavier burden than they would have had to show otherwise in order to keep you from practicing your religion, even if it's doing something which would normally have been in violation of the law.
Right. And what will happen is, since that all religions are equal, by virtue of the statute, that if there is an exception carved out for one religion, that's my argument, if there's a little exception carved out for one religion, it is carved out for all religions in exactly the same way. And if one religion then can use marijuana or peyote, then all religions can use marijuana or peyote immediately.
And of course, most
and
of us
that they would regulate, then those religions would be self-regulating as to the nature of that use or the manner of that use, as long as it was used in some sacramental way, or, you know.
And just
I've talked to enough
footnote.
hippies. It's all sacramental to them.
Just a footnote to that. We're probably all familiar with the snake cases, or the cases where people would not allow their children to be treated.
Yeah.
And then to get back to Steve, let him continue with the questioning.
Well, I'm going to go off in a slightly different direction. Maybe one of the constitutionalists in the group can help me understand this issue. As I said in my earlier round of questions, freedom of religion is already protected in the U.S. Constitution.
Oh, absolutely, yeah.
The state of Idaho and all the states can extend those freedoms beyond what the framers of the Constitution had in mind. They just can't restrict them further. Is that a fair layman's interpretation?
The First Amendment is applicable to the states through the window of the 14th Amendment. I had to memorize that when I went to law school. Yeah, it's the incorporation of the Bill of Rights, and it's applicable to the states, and it's enforceable by the federal government, by the federal judiciary. A state can have a law that tends to create more freedom, but it cannot violate, the state cannot violate the federal Constitution as it's interpreted by the Supreme Court of the United States.
On that note, I have to bring the program to conclusion, but the good news is you'll be back next week and we can pick up on this subject at that time. Norm Gissel, an attorney in Coeur d'Alene, we thank you for being with us on part one of this series that we're dealing with, the Free Exercise of Religion Act that went into effect in Idaho on February the 1st. And I thank the panel for, again, their very fine questions. We look forward to having you back next week. Ladies and gentlemen, I hope you'll join us when we do part two of this important discussion of this new law in Idaho. And following Norm Gissel next week, then we will have programs with those in support of the law that will be with us on the programs following that. And I hope you will join us. And for you outside of our state, it's also an important issue to you. I would like to invite you to be with us again at that same time. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station. Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guests.
On today's program, we're continuing our discussion from last week on Idaho's new law that went into effect on February the 1st, 2001. It's called Idaho's Free Exercise of Religion Act. About 9 states have passed this law. Previous to that, in the early 1990s, the Congress of the United States passed such a law, which was declared unconstitutional by the U.S. Supreme Court. However, the states are following up with state laws. It is a controversial act, and last week and again this week, we have an attorney that opposes this legislation. Following these two programs, we will invite a guest who supports those laws in Idaho. Our guest is Norm Gissel, who is an attorney in Coeur d'Alene. He's best known for his litigation in which his clients, the Keenans, were victorious over the Aryan nations in a trial in the year 2000 in Idaho. Norm, welcome back to our program from last week. It's a fascinating issue, and we appreciate you taking the time.
Thanks for having me back, Tony.
And as always, I'm pleased to have our regular panelists, Janelle Burke, an attorney in the state of Idaho, and Steve Schenck, who is the Vice President of College Relations and Development at North Idaho College. And we just got started with the round with Steve last time. and we'll pick up with Steve starting the first series of questions.
Thank you, Tony. I think I have to note for historic purposes that in 15 years of doing this show, this is the first time I've ever started a round of questioning, unless it was just Tony and myself doing the show.
It's a historical moment.
It's a very historical moment. I'm almost befuddled by the honor. Norm, I think for the benefit of the viewers who did not see last week's show, I ought to give you an opportunity to kind of briefly summarize what we're talking about here, because it's a pretty complex topic. I'm still trying to understand it. Maybe we ought to try to catch them up.
I'd be happy to. And the topic of our discussion is a statute called the Free Exercise of Religion Protected Statute. It was passed, interestingly enough, last year in 2000, and in March became law, but it didn't have any effect and sat on the books until February 1st of this year. So it's actually been law for only 20 days. It is a law that changes the nature of our society and changes our relationships with our government in serious and profound ways. And that's why we're here talking about it. If this was just tweaking the system or fixing a problem, we wouldn't be here today. This is a society-changing event, and it deserves to be thoroughly understood and reviewed. And in that connection, I didn't mention last week, but I want to mention this week that the statute can be found at 73-401 Idaho Code. Every county public library has an Idaho Code section. Every attorney has an Idaho Code, the body of Idaho codes. And your county law libraries all have this statute. And it should be required reading for every citizen in the state of Idaho, because it affects every citizen in the state of Idaho.
If I can, just real briefly, I think that I've now visited with you enough to know that at least I think, that you have two fundamental objections to this law. One is more philosophical and broad, and that is that it grants special protection, special rights to a specific group of people who are religious or who claim to be religious. Yes. That's one issue. The other is a more practical concern, though, based on some of your comments in the last show, and that's that people will abuse this new law. They'll look at it as a way to make legal activities which are clearly supposed to be illegal in the state of Idaho. That people may commit crimes and say that crime was an exercise of religion, that they may use illegal drugs and say that's an essential part of the practice of my religious beliefs. Now let me leave the first issue, the philosophical issue, alone for a minute and ask you a question about the second one.
Sure.
And I see where you're coming from, but are people going to say, oh, that's just fear-mongering? We can easily deal with that. This legislation was never intended to grant those loopholes or privileges to people, and we'll take care of that. How do you answer that question?
Well, first of all, as I indicated at the start of this second hour, they've had well over a year to examine and discuss this, and all of these issues have been raised. There's nothing new about what I'm saying that the state legislature has not already heard. And they've chosen not to amend this law. What they want to do is, I think they want to experiment with us for a little while and see what problems arise and then fix the problem later on. I don't know whether that's wise legislative practice or not, but that's what we are essentially social guinea pigs to see how we react when a particular law is foisted upon us, essentially.
If Tony will allow me one more question, and this is speculation, so maybe I shouldn't do it, but I'm going to anyway. Do you have some sense that the legislature passed this as sort of a feel-good bill? I mean, it's about religion. Most people agree that religion's a good thing. This is a very religious state that came from a national source. Oh, sure, this is a good thing. Let's pass it. That's number one. Number two, surely if these things have been discussed, and I hadn't heard them before the show, are they now saying, oh my gosh, if we try to deal with this, we're going to be painted as being anti-religious, and we don't want to go there, so they're just trying to ignore it? Is that fair speculation?
This is far too serious of legislation to have been reviewed by the state legislature and have it passed as feel-good legislation. If you want to do something to feel good about something. What you do at the Idaho legislature, you pass a resolution, you don't pass a law. That's
point.
number one. And number two is that the state legislators are sticking to their guns on this, and there's massive support at the legislative level for this law in its present form, because they had opportunities, plenty of opportunities, to amend this, and they refused to do so. So this is a profoundly serious law that changes our society, changes it materially. It makes a hierarchy of citizenship where there was none before. And when you do that in a democracy, you're doing it with serious thought behind it, because democracies don't operate, at least the democracies that I want to participate in, don't operate on the basis of privileged hierarchies. It operates on one man, one vote, equal opportunity, and when we stand in the bar of justice, we are all equal. That's a democracy to me. And this law changes that, and changes that in ways that will adversely affect all of us, in my opinion.
Thank you very much.
Those questions were just excellent. It was such a clarification on a very complex issue. I want to do a follow-up from Steve that he really covered the philosophical and the practical questions, but I want to do a couple of case studies, hypotheticals, and I'm doing that because you're an attorney and you can be very helpful to us with all the attention you've given this, as I'm sure the supporters will later too. Let us suppose that someone comes before the court, a gentleman, and he's had a deep religious belief a long time and sees this law, and he reads the Old Testament where spare the rod and spoil the child, and he interprets that to mean, and he can quote from it and then use this legislation, and he beats a child, his own child, so severely that the child bleeds from the beating, or maybe even has an injured rib. And he says, I'm doing this in the name of my interpretation of my religion of the Old Testament. Does he have more defense now in court from being convicted because we have this law than he would have without this law?
Well, in this area particularly, there's going to be a profound change in the way and the manner in which the Department of Health and Welfare and the state of Idaho, the law enforcement officials, apply this law. Nobody is suggesting, and I certainly am not suggesting, that some man in a religious frenzy can kill his child and get away with murdering his child through the assertion of his rights pursuant to the statute. That's not going to happen.
And I wasn't suggesting
No,
that.
but there's a huge area of human conduct that we have, through years of legislation and through years of discussion and contemplation, have said that this conduct, a particular type of conduct, is harmful to children, like starving them for 4 days or 5 days. That's child abuse. We all recognize that. We have to re-engage in that arena on a case-by-case basis throughout the state of Idaho to readdress all of these things.
Because of this law?
Because of this law. And everybody who is accused of child abuse, if they have an attorney of any quality and any level of advocacy whatsoever, the first thing the attorney is going to do is sit down and determine whether there was a religious basis for the conduct that they are accused of, that has an appearance of child abuse. And so there's going to be a large number of people who will assert a religious defense, and the burden in the state of Idaho is going to be so high to prosecute the religious defendant that they'll have a chilling effect in their prosecution, because the attorney's fees side of it is unbudgeted. The man is accused, there's a big court suit, for some reason he wins, he's asserted a religious privilege somewhere along the way, he gets attorney's fees and costs of suit. That could be, he could have brought in experts from around the United States. He could have rung up huge attorney's fees, investigators' cost, which, some or all of those could be applied to this. And then and I just want to make one more point, and I'll get right back to you. Then when he is sentenced, say he is found guilty, it may not end there, because the good advocate will also say that it's part of his religion that he shouldn't be sent to jail. So there will be a search throughout the state of Idaho for a person who only got probation for this act. And if that person, say in Minidoka County, got probation, then why couldn't I, in my religious zealotry, get probation as well? So it may even affect on the sentencing side of things. It may have an impact. And I certainly, if I get the right case, I'll certainly assert that as an advocate for my client.
I want to go to another case study, or example, I should say. It's a hypothetical. But before I do that, suppose a family, and there are religions that believe this deeply, that they don't believe in medical intervention. They believe only in healing by God. And so a child was to have an appendicitis attack or an abscessed tooth, and they refuse to take them to the doctor, and let's suppose the tragedy is death because they don't get medical treatment. Does this law too could be used as part of their argument in defense if there was an attempted prosecution?
Right. It gives them an additional shield, as there's a child that died of meningitis, a 3-year-old child died of meningitis in Colorado not very long ago, and there was a religious defense, and they prosecuted the parents for the criminal neglect of their child. This type of case would build an extra shield for those people and would give them encouragement to assert a religious defense, whether they were, let's assume they weren't religious, but just believed the child wasn't ill. The child had meningitis or something of that nature. Well, the child will get over it in a few days, and the child languishes and dies. There's nobody there to assert the religious beliefs of that for that poor little child that died. But those folks, whether they were religious at the time, they'll certainly be religious by the time they get to court when they're defending against this crime of allowing their child to die from meningitis.
One other example, and then back to the panel in another area, another hypothetical. Let's suppose there's a corporation for profit, and they are going before planning and zoning for a change that would be very helpful to that corporation, its future economic viability. And I'm next to that development, and I belong to a religion, let's suppose, that can use some very strong arguments that what they're involved in their development now would somehow affect my religious beliefs, would impact the community in a way that would affect my religious dogma. Under this law, I could go to court to argue that, but the corporation cannot, because the corporations cannot, for profit, cannot argue a religious philosophy.
Yes, you have understood that. As I indicated that in the previous hour, a for-profit business a for-profit corporation, by definition, could not assert a religious purpose because it's only has in existence because it's a for-profit entity. That corporation seeking the zone change to build a huge factory that employs 300 people may not get their zone change because a person raises a religious opposition to the zone change based upon and what good argument could the state have? The state says that this property is R1. The corporation wants to change it to a commercial zoning or a manufacturing zoning, which would benefit thousands of people in the community. But the religious opposition to it would be that I bought this property, I lived here because it's R1 zone, and I have a religious affinity for R1 zones.
I meditate every day at noon.
And I meditate every day at noon, and I can't meditate with all this traffic. And how can a state assert that changing the law, that there's a compelling need to change the law because the law already exists as R1? It would seem to me, and again, we don't know the effect ultimately, but it would seem to me that religion would trump a zone change on every occasion. And what they'd have to do was have to get an individual to attempt the zone change, and there would be a religious reason for wanting the zone change. There'd be an equal and opposite religious desire to keep the zone the way it is, and then the two religious beliefs would cancel one another out in some sort of religious, divisional fractions, and then they try the case on the merits like they've always done before. But what that does, that cheapens religion, and it makes, and I point this out as philosophically, there's another side of all this, is that religions are important to American society. They're essential to American society. The health of America and the nature and character of America would not be anything like it was if it weren't for the wonderful contributions to our society that religion brings. But when religions, it seems to me that when religions go out into the secular world of planning and zoning and criminal prosecution and child abuse and use these great values that they have created over hundreds and hundreds of years, and they use those in a secular way, they become not religious beliefs so much as coins of secular advantage that they're willing to spend to seek special rights and special situations in the secular world. And I think when you trade your great religious beliefs for secular advantage, I think your religion suffers.
Thank you. Janelle Burke.
I want to ask you a question about the exercise of religion, and I'm going to read right from the code. Exercise of religion, and this is the definition, means the ability to act or refusal to act in a manner substantially motivated by a religious belief, whether or not the exercise is compulsory or central to a larger system of religious belief. Now, there's some danger in that, and lots of times we think of religion in terms of organized religion, but this doesn't say that it has to be an organized religion at all.
Right. This law, to me, specifically invites a person to assert a single religious belief and assert that single religious belief, say for the use of marijuana. I mean, the person that's arrested for consumption of marijuana would, to assert the values, to assert the power in the statute, could assert the single religious belief that using this drug somehow brings him closer to God, or gods, as the case may be. And it doesn't have to be connected with organized religion whatsoever. Each person in Idaho, under this definition, could have his own or her own religion. And it doesn't have to be tied to the Mormon religion or the Catholic religion or the Lutheran religion, any religion. And in that connection, as in a talk that I gave earlier a couple of weeks ago, there's the devil worshippers. I mean, they believe in a higher power. They believe in the devil. And this is the first time in the recorded history of mankind, as far as I can ascertain, where a state legislature has passed a law that says, devil worshippers, we invite you to sue us, and if you're successful, we'll give you attorney's fees and costs of suit. That is the uniqueness of this form of law, because it addresses religious action and not religious belief.
Norm, given your last statement and your answer to a previous question where you talked about the real value of religion to our society, and the fact that this law, at least in your view, actually may endanger and diminish that value, put it at risk because it moves it into realms where it shouldn't be, at least in our legal view, in our old legal system. Are there religious leaders who are saying this is a bad idea?
Yes, there are. I've met a number of religious leaders that are appalled. One religious leader is a very thoughtful gentleman, says that in business, the rate of the coin of exchange is money, and money, you exchange money for value. He says, in my business, it is goodwill and honesty and observance of his religious tenets. And he says that if I put those at risk, if religion is made a mockery, if it is made secular, then it harms my religion, and I lose my special place. It is the reverse of the argument about the rights of men and women. People have said, well, if women want to be equal to men, then there's an essential quality of femininity that they must therefore lose. Nonsense argument. But I mean, on this side, though, there is a real risk, that when you take your sacred beliefs and you make them secular commodities of exchange, to use them as pieces of power, it puts your religion at risk. And particularly when the absurdity of taking devil worshippers and increasing them in status and power over people who are atheists or people who are agnostics or people who simply, as a matter of principle, refuse to disclose to government what their religious beliefs are. Because if there is one entity in all of the world that has no duty to know what your religious beliefs are, it is government. But this statute requires that you necessarily must relate a religious virtue to the tribunal hearing the case to assert all these powers.
Do I have time for another question? Speaking of tribunals, what remedy is there for this legislation? For people who do oppose it, what do you see as a likely course of action?
The way to deal with this statute is for its repeal and a profound apology by the state legislature and the governor to all of those that have been adversely affected by this, even in the 20-day span that it's been in existence.
But
the chance of that happening is nil, but that's what should happen.
Are there other remedies?
Well, there's going to be constitutional challenges that are brought very rapidly on this. But those take, a well-argued, well-thought-out constitutional challenge. It's going to take 4 years.
And
we're
maybe I
going to
should leave this question to Tony, but what venue? I mean, if somebody in Kootenai County or in another county in Idaho wants to challenge this, is it going? What kind of court? I mean, it doesn't have to go to federal court right away, does it? It would go.
No, it'll go to the state court. It will go through the Idaho Supreme Court, and then from the Idaho Supreme Court, if they receive an adverse ruling there, it would go directly then to the United States Supreme Court. But that's a very expensive process. You're talking a good, solid challenge to the brought before the U.S. Supreme Court. You're talking $300,000-$400,000. But of course, if you're lucky, you get it paid for by the taxpayers.
I to follow up on Steve's question. We have a little time left. I can't resist looking at the constitutional question, and Steve knew I would head there. If, in some of the examples you've given, that someone could, for example, as your interpretation of the law exists, they could use marijuana or something if they were doing it for religious purposes, and someone who was doing it not for religious purposes would go to jail and the other one would not. That is treating citizens differently if that interpretation is correct.
Right.
Then would you not argue before the court under the 14th Amendment of the U.S. Constitution? Of course, the state has a provision likewise in the state Constitution that you're denying persons equal protection of the laws. The citizens are being treated different, and that you might prevail with that issue.
Oh, absolutely. Absolutely. It could fold both ways. So the secular marijuana smoker, if there's any left in Idaho, I doubt it, but if there is one, then he would argue on the other side that it's a denial of his equal protection. So one way or another, it'll get challenged. I think also we have a constitutional right of privacy since Griswold v. Connecticut in 1964. I also think that there's a serious invasion of privacy. To become a full citizen, I have to proclaim a religious right. I think that is a denial of my right of privacy, to keep my religious views to myself. So there's another constitutional challenge that's available.
You're a native of Idaho, and you understand the Idahoans, in addition to being deeply religious people on the whole, they also are great lovers of privacy. So are you saying that there is something here else that the citizens may take a look at, too?
Yes, I think on the privacy thing, I think that every Idaho citizen that I've ever met has a deep sense of privacy and a deep respect for his neighbors and his neighbors' privacy. To have the government mandate that to become a full citizen now, you have to declare a religious belief to assert your full citizenship, I think that is just going to run against the grain of the Idaho culture. And I think it would fail just on that if everybody understands what's happening and everybody reads the statute.
At this point, I can assume that the great majority of Idahoans are not aware of this legislation. As Steve has indicated, it's a complex law. but will that awareness from your perspective and your concern increase as some case will come forth on this issue?
Absolutely. In fact, the media is very interested in this finally now. I've talked to 3 or 4 attorneys that were wholly unaware of this, and I reel it out for them and show them to them. And there's going to be a lot of publicity about this because these cases will each have an interesting set of facts, and they'll start working their way through the legal system, and they'll be highly reported. They'll be interesting and highly reported cases.
On that note, I have to bring the program to conclusion. Norm Gissel, on behalf of our panel and our staff, thank you for your 2 weeks with us. It's always great having you on our program. You're always so informed on each issue. Ladies and gentlemen, again, we have brought you a 2-week series from the opponents of the Idaho Free Exercise Religious Act that went into effect on February the 1st, year 2001 in Idaho. Next week, please join us when we will start the series with the supporters of the Idaho Free Exercise Religious Act that will be in support of the law and explain why they think it should remain a statute in Idaho. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station. Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guests.
Our topic today is the Idaho Free Exercise Religion Act that took effect on February the 1st in the year 2001. The last 2 weeks we have had an attorney that has opposed this law and gave all the reasons why he and others are in opposition. Today and next week we're very fortunate to have as our guest someone who's on the other side of the issue, that is supporting the law. I welcome to the program Robert L. Aldridge from Boise, Idaho. Our guest holds a BA degree from the University of Idaho, and his Doctor of Jurisprudence or Law degree was received in 1970 from Washington University in St. Louis, Missouri. Our guest is admitted to practice law in the state of Idaho, also before the Ninth Circuit of the federal courts, and he also is admitted to practice in the United States Court of Claims. Our guest has been recognized and known for a number of cases that he has been involved in. One of the most well-known is that he was co-attorney for the Boise JCs on the Table Rock Cross versus the ACLU with the American Center for Law and Justice that he represented in the case. He lectures on church law and taxation throughout the Pacific Northwest and around the country. He has been a panel member on many debates that taking an opposite side of the ACLU or the Idaho Humanist Association, other organizations. Our guest is also interested in historical activities and historical preservation. He's interested in music and has a lot of charitable organizations that he works with. Mr. Aldridge, welcome to our program, and thank you for presenting the other side of this issue over this 2-week period.
Thank you. I'm very glad to be here.
Thank you. And as always, I'm very pleased to have our regular panelist, Steve Schenck, who is the Vice President of College Relations and Development at North Idaho College. And Steve Schenck will start the questioning today with Mr. Aldridge.
Thank you, Tony. Mr. Aldridge, it is a pleasure to have you here, and I'm going to say for the audience that I feel a close relationship to them in this show. I'm trying to represent the layperson's view, neither a lawyer or a political scientist, which is why I'm going to ask you to begin our show today by giving us a pretty thorough background, if you would please, on what got you interested in this legislation and what steps led to its adoption in Idaho.
To really understand the act here in Idaho, you have to understand the national things that have happened. throughout the history of the United States, the First Amendment in the free exercise of religion and establishment clauses placed a very high emphasis on religious freedoms. And up until approximately the 1940s and even more so in the 1960s, religion had a very prominent place and a very protected place. So much so that, for example, in 1893, in a case called the Holy Trinity case, the United States Supreme Court said that you couldn't even construe a statute in a way that would harm religion. It was basically against the rules. That has changed over time and has dramatically changed beginning in the 1960s. In the 40s, we had some cases primarily relating to such things as people who refuse for religious reasons to have treatment medically or for children and so forth, some things of that nature, but not too much. In the 1960s, we began to see what would be characterized as removing the Bible and God and so forth from the school systems, from public life and so forth, in a lot of cases. Out of that came a standard that had been applied pretty much across the board in most cases, Wisconsin v. Yoder, Werner case, Sherbert case, etc., which had a multiple set of parts to it. Number one, you look to see whether there was a substantial impact on somebody's exercise of religion. So you didn't look at minor things or things that didn't have much impact. If that occurred, then there was a two-part government test that had to be met. Number one, was there a compelling government interest? What that really meant was, did the government have some real solid reason to come forward with this legislation or regulation? And such things as child safety and Voting Act situations and so forth have always been those kinds of compelling interest. If that compelling interest was found, then the government had to show that the means they were using were the least restrictive means of achieving that result. In other words, if there were a series of choices of how to do this, and they were all rational and reasonable, you picked the one that was the least restrictive on the religious exercise. You tried to accommodate that religious exercise. Those worked very well for quite a number of years. Then a case came up, actually came out of the state of Oregon originally, where a couple of men who were working for the state of Oregon got fired for using peyote and then were detected in that, and they applied for unemployment benefits. The court case went back and forth through the state levels of cases up through the Ninth Federal Court and Court of Appeals, and finally to the U.S. Supreme Court. The Supreme Court in its decision, which was a 5-4, very fractured decision, with a lot of concurring and people in and out of the majority side of it, came up with something that was really brand new in the whole history of looking at religious rights, which was to say that unlike everybody else's analysis up to that time, in fact, they thought that any religious rights case had always been kind of a hybrid case, that had been combined with other free exercise of speech or some other fundamental right. And so that all of these cases that established this two-part government test and so forth really didn't apply to a purely religious claim. And they came up with a new standard. And that standard was dramatically lower in terms of its protection of religion than the existing test had been. This provoked a firestorm, literally. And as a result of that case, which happened in 1990, in 1993, the U.S. Congress unanimously, in a bill that was supported by literally everybody in the entire political spectrum, the entire spectrum of all kinds of beliefs, passed a bill that was called the Religious Freedoms Restoration Act of 1993. That really and fundamentally reestablished this two-part test on the governmental situation. That was in effect and didn't really seem to have any problems until 1997. In 1997, a case came up again to the U.S. Supreme Court that came out of San Antonio, Texas. And that case was in the context of historic preservation. That's one of the reasons I was interested in this, because I've done a lot of historic preservation work. And it was a conflict between a Catholic church and the local Preservation Council over whether or not the Preservation Council could put some limits on how they could expand, what they could do, what kind of changes they could make to the church. When that case hit the United States Supreme Court, part of the analysis was of the Religious Freedoms Restoration Act. And the court, in looking at that, decided that even though RFRA as a national act was okay, and is still in effect technically, that the United States Congress could not apply this to the states and tell the states what they could do. And so that part of RFRA, as it attempted to affect something inside the states, including Idaho, was unconstitutional. As a result of that, the emphasis shifted. And two things have happened. Number one, there has been a movement, which is, again, widely supported, to have individual states bring their own religious freedom acts of various kinds. That led to the act here in Idaho. Number two, this last year, Congress again passed unanimously and was signed into law on September 13th by President Clinton, what was called the Religious Land Use and Institutionalized Persons Act. That's a more restricted version of the original RFRA that applies only to, number one, religious land use, so zoning issues and such regarding churches and those sorts of things, and to institutionalized people, which covers not only prisons, but also people in nursing homes and so forth. So those areas have been carved back out and are now covered again by federal law. That happened after the original passage of the law here in Idaho, so at the time the Idaho law was done, that wasn't in place. In any event, a very broad coalition came together, for example, 14 different Jewish organizations and literally hundreds of other organizations, and started going state to state and passing these local statutes that are styled in different manners. In Idaho, it's called the Free Exercise of Religion Act, and that came in last year's legislature. This broad coalition has been essentially the coalition that was there in the original RFRA, with the exception of the ACLU was pulled out and a couple of other players, but by and large the majority has been those. So that's the background to the Idaho Act.
Well, Mr. Aldridge, thank you very much for that very comprehensive and easy to follow explanation. I appreciate that.
Yes, thank you, Mr. Aldridge. We'll go on with that, and a couple points of clarification, and you certainly are very familiar with that. There has been I guess a misconception that the Religious Freedom Restoration Act, the federal act, was declared unconstitutional, and you're saying it was not. It was simply that there was a federal states' rights issue here that in some areas, and it must be left to the states.
Yes, and there have been a number of cases in bankruptcy law and such where RFRA has still been applied. When this first happened, we in the field of looking at the Supreme Court thought that this was kind of an aberration, and the Supreme Court had suddenly gotten religion about states' rights for the first time in a lot of years, only because of this result they wanted to reach. However, recently in the American with Disabilities Act, the Supreme Court again held the exact same thing, that you could not have Congress telling the states what to do, and again upheld that federal-state dichotomy, 10th Amendment and so forth. So this may be a coming trend. We may see the Supreme Court doing this on an ongoing basis. But yes, RFRA as a whole was not declared unconstitutional, nor was the principle of RFRA declared unconstitutional.
Yes, I agree that a lot of constitutional law experts are saying that the present makeup of the U.S. Supreme Court is looking at the 10th Amendment and is moving more things back to the state, and this would be an example. Now that this law was passed in Idaho in the year 2000, and I know you were very much involved with others in its passage, and then because of some debate and opposition, it was had a little bit unusual date for implementation, which was February the 1st, year 2001. I have 2 or 3 questions along that line. One is, now that we have the law in Idaho, how many states have followed the same path that Idaho has, following the 1997 decision of the U.S. Supreme Court that did direct portions of that law back to the states?
The last time I checked, there's approximately 18 to 20. There's a little bit of range in there because some states already had constitutional provisions in place that paralleled or had existing other statutory things in place prior to this state act that would be the same exact test. Idaho also, by the way, had a court case, the Osterhaus case, back in 1993 that had in fact adopted this 2-part standard here in Idaho, had used it in religious analysis. So to some extent we already had this in place as an Idaho doctrine.
So we are getting close to half the states with such a law. Let me pursue a little bit further the content of the law, and in our show next week, and I hope our viewers will tune in again next week, we'll probably get into some real intricacies of what your opponents say about the law and how you can respond to that. But again, in your very clear explanation at the beginning of this program, and going back in earlier history, it is my understanding from what you're saying that the law that we now have on the books in Idaho would require, in all of these issues when they arise and if they become a court question, that this 2-part test will be in place of the compelling government interest and taking the means that's less restrictive on religious issues. Is that correct?
Yes, and again, remembering that a lot of areas have been carved out by overriding federal law. So this is limited, number one, to state statutes, and number two, to areas in which there's not this overriding federal situation. So a lot of things like employment law, housing law, a lot of those things are already covered by federal statute that preempt anything the state of Idaho would do in terms of lowering the standards. you can always raise them, make things more protective and so forth of whatever the protected minority or class is, but you can't lower them. So it is a relatively restricted, and especially now with the Religious Land Use and Institutionalized Persons Act in place, that carved out two major areas that had been a lot of conflict. Number one, the zoning issues regarding churches and such, and then number two, prisoners' rights. That's a difficult area because you have people who, number one, are in a very confined area and have a great need to be controlled in a lot of ways, but still need to have their religious rights, and that's a much more difficult situation than members of the public.
Of the states that have passed laws, I'd assume they're very close or maybe identical to the Idaho Code that you had also viewed those other states. Are all those states' laws still in effect? Are there any court challenges either in state courts or federal courts? What is the status at this time of those laws that are in other states such as Idaho's?
Of all the legislatures that have considered this so far and passed it, only one of them was vetoed, and that was California. And I'm not sure that would be the case now. That's a different governor than is there now. But in all the cases we checked with, we went to each state before we even introduced the bill in the Idaho legislature and asked them, had there been any problems, number one, were there any challenges in effect? And then number two, this year, right before the effective date, so it's starting in January, we again went back to those same states and asked them, have there been problems? Have you had court cases? And in every case, we were told no. There have been absolutely no problems. It's been in place and working just fine. We've had no challenges.
So there's been no challenge at this point. Now, another area I'd like to get into, and then I'll go back to Steve Schenck for questioning. Oftentimes when we get into certain issues, reapportionment is a good example of that. You will find as you go from state to state, you'll have Republicans and Democrats on the same side, and Republicans and Democrats on the other side are conservative, liberal. And I sense that is the case with this particular issue. Would you be so helpful to us as to indicate in the coalition, those supporting, opposing it, you alluded to this a little bit earlier, it's not a conservative, liberal lineup in this situation, is it?
No, if you look at the membership by and large of those who are in opposition, you find a very heavy component of either ACLU members, board members, or people who have been pretty active within helping the ACLU. That's the major organization that really has been in opposition to this. In terms of the debate in the Idaho legislature, there was a real problem in that a lot of people who stood up and debated against this said that they were representing various national churches. When we started checking, we found out, in fact, that was not true. Those churches were still part of the state RFRA coalition and were actually in favor of those. So I think here, Idaho has a very unique situation. We haven't seen this in any of the other states out there where there's been people who are spread through various churches, but nonetheless have this kind of thread going through it of the ACLU membership and or belief in that particular system.
One final question before going back to Steve Schenck. Let's just talk about Idaho rather than at the moment than the national. From what I'm reading and observing, as this debate is somewhat intensified across Idaho in just the religious community, leaving out other institutions or components, that it seems that the religious community is very divided. There are very prominent spokespersons in the religious community that are opposing this legislation as well as others who are supporting it. Is that a fair conclusion?
I think that has two sides. One, in terms of the churches themselves whose leaders have come out in opposition, yes. There's unfortunately a fairly dramatic split in that. That's unfortunate because I think that realistically the bill actually helps all of those people. However, again, I think that a lot of those church members who sit in the pew, if they really understood all the issues, would not necessarily be in opposition. As a matter of fact, I think they would be in support. A lot of the problem in this whole area has been a lot of misinformation and a lot of just plain lack of information. I think that's why programs like this are excellent, because they get this information out and people can check. These are things that are not hidden. There's not arcane knowledge here. You can go look at the statutes, you can go look at all of the things that have happened both nationally and in the state of Idaho and then decide for yourself.
Thank you. Steve Schenck.
Mr. Aldridge, I'm going to go back over some things that you've already said and said very well, but I think it's important for me, and I'm hoping for the audience too, to kind of process this in simpler, maybe less legalistic terms. Tell me if I've got this basically correct. For the first 190 years or so of this country, there was great protection of religious freedom, and the Constitution was primarily applied to ensure that the state, either the federal government or states, did not establish official religions. Is that a fairly accurate statement?
Yes, that's very true. The wall of separation that's been alleged, and of course doesn't appear in the Constitution, was keeping the government out of religion, not keeping religion out of the government.
But then starting in the 60s, there seemed to be a shift toward a much stricter prohibition of any religious activity in public settings, in public schools, public colleges and universities, state or local subdivisions. Is that also a fairly good summary of the shift that took place?
Absolutely. Prior to the 60s, there were almost no cases where you had the government in any of its forms down to the local level against religion. Just didn't happen. Since then, we've seen a tremendously dramatic increase in that. And so now it's almost to the point where, as unfortunately as usual, we seem to swing the pendulum to both sides but never in the middle. Now the government almost seems hostile to religion. I think that was the background that led to the national RFRA that leads to the state RFRAs of saying we need to get balance. We are no longer the society we once were. We are now much more pluralistic. We have a lot more diversity, and so we have to reflect that. But on the other hand, we don't have to suddenly turn religion into the whipping boy of society.
That's an excellent segue into the next question I had intended to ask, which I hope you haven't totally answered it because I'm going to give you a chance to tackle it again. I was going to ask you for me and for the audience to give us some of the reasons why this legislation is necessary. What problems, from your perspective, needed to be addressed and are addressed by the Free Exercise of Religion Act in Idaho?
Part of the problem is that, again, society as a whole has changed. In the older days, you didn't really have to worry about the government coming in and causing problems with religion because the whole society was in support. We no longer have that. And so now there's some active hostility out in every place from schools to all kinds of governmental situations. Zoning was a prime area that this happened. And across the United States, we often saw cases, for example, where in one case that's been reported, there were only 4 churches in the town, and the local zoning authorities promptly zoned those as the only allowed church areas in the whole town, which effectively froze out any new churches coming in. We saw a lot of those sorts of things. In South Carolina, there was a case where, and in other states, if you are a certain type of Orthodox Jewish, you can only walk on your Saturdays. You cannot ride. You're not allowed to do so, and you have to go to a local meeting that's within walking distance. And so they would have these at homes. Obviously, they were not impacting traffic or anything else. Nonetheless, local zoning authorities would forbid them the ability to go to one of the members' house and meet there to go through their ceremonies. So those sorts of things were happening across the United States. The school situations have been sometimes dramatic. Back in Indiana, a young boy that bowed his head in silent prayer over his lunch was taken out and disciplined. Those sorts of things have happened. In many cases, I think they're based on ignorance. Very many times the schools think that there's just, quote, separation, or that we can't even mention God, etc., and that's not true. But they sometimes overreact and react in very negative ways. And again, that's where a lot of this coming back to the middle needed to happen. Religion has its place in society. It has its place in the law, and it needs to be there. It's a fundamental part of our entire country still. Even pluralistic as we are, it's still really the basic for the morals and the laws of this nation, and that needs to be recognized. On the other hand, we're not going to have probably the situation we once had where everything shut down on Sundays and you couldn't sell anything in stores on Sunday morning. That's not going to happen again. That society is gone. And so we need to find this balance between the two that protects without giving an overriding place or does establish a government religion.
Thank you very much.
I want to go back to that, and I think I'm correct, Mr. Aldridge. The case that you referred to, the 5-4 decision, the U.S. Supreme Court was on peyote was from Oregon, the state of Oregon, I believe. And as I understood the case, the individuals who wanted to use peyote in relation to religious service, and I give that emphasis that it was Native American tribes around the country, many of them in their specific religious beliefs do use in a very solemn way peyote, not on a daily basis. And yet the Supreme Court said that Oregon had the power, if it chose, to restrict the use of peyote, that the compelling government interest was greater than the religious right. It's my understanding that following that decision, returning to the states, that Idaho chose then to act rather immediately to pass a law protecting the use of peyote in Native American religious services. So this long introduction to my question is Idaho reacting very quickly to those kind of decisions or laws when they happen in relation to this question?
Yes, it does. And I think that's in part because Idaho has a pretty high percentage of people who identify themselves with one religion or another, a very high percentage. And so I think the legislature simply reflects that. When something happens that affects religious rights, you're probably going to see something happening in the Idaho legislature to either counter that if it's something they see as threatening, or to carry it out if it's an opportunity given for a state to do something. Remember also that we're talking about three different kinds of religious situations. One is religious thought. Religious thought is absolutely unable to be in any way impacted by the government. You can think anything you want, whether it's freedom of expression or freedom of religion. Number two is speech. And there, the courts in the overall speech areas have gone into a lot of differences between commercial speech and political speech and so forth. But religious speech has always had a very high standard of protection. Number three is religious action. That's where the problems have come. When you want to act and physically do something, now you are definitely affecting other people, and you can get into situations where the state has to choose between how bad is that affecting other people versus how bad is it to restrict your religious action and conduct. The peyote situation is one case where the Supreme Court said that this has so many other aspects in terms of drug use and its effect on society that the state can validly restrict that usage, and that probably is correct constitutionally. On the other hand, if there's something that's very benign in its effect, the state should not be able to restrict it because you don't have that overriding compelling state interest that's protecting somebody else.
As I read the court case, when it returns the issue to the states to make a decision, where they said, Oregon, you could restrict the use of peyote, and Idaho says, we'll go the other route. When the U.S. Supreme Court under federalism allows that to happen, then as one travels or moves from state to state, one's going to find law and policy being somewhat different from state to state in relation to some of these issues. Is that correct?
Absolutely correct. That's one of the reasons why they tried to do this originally by the National Act. It was trying to say there is a overriding single standard for the entire United States. You don't have people fleeing to one state because it's more open, or if they happen to be opposed, fleeing to another state because they think that it doesn't allow us religious bigots to act, whatever. You don't want to have that, just as we had that same problem in many of the cases involving aid to dependent children and so forth, where various states became welfare havens and others were deemed to be very harsh on welfare, and so you had people moving to one and fleeing the other. But I think that's now a fact of reality. If in fact the Supreme Court is saying, and going to continue to say, that the states do have rights and can vary these things, you are going to see states that are more protective and others that are less protective.
And so residents or citizens, as they go from state to state, would have to be cognizant of that. It would also affect where one would choose to live, because in some states one would have more flexibility to act than they would in other states.
Certainly. If you look at states, for example, in terms of homeschooling, there are some states that are very, very, very friendly to homeschooling. There are others who are pretty hostile to it. And so, again, you have people coming to a state, if they want to homeschool, searching out those states that are more lenient, that give them more opportunities, and avoiding moving to those states that don't have that. I suppose that's one thing we could probably advertise through the Department of Commerce, that along with the good streams and fresh air and everything else, you have religious freedom in Idaho.
We're about out of time, but good news is you'll be back next week. But so the issue is that some of these things might be more uniform if we do them at the federal level.
Yes, I have to say, however, I'm not a great fan of doing things at the federal level. I think the Supreme Court is probably correct in saying this should be a state issue. Remember also that every state has different constitutional provisions, and Idaho has a very, very strong protection of religious freedoms constitutional provision. On
that note, I have to bring our program to conclusion. On behalf of Steve Shink and our panel, I would like to thank Mr. Bob Aldridge very much for being on our program dealing with Idaho Free Exercise Religious Act. He will be back with us again next week, and next week, Mr. Aldridge, we will also have some questions about the opponents' arguments and let you respond to those. We've enjoyed having you this week, and we look forward to you being back with us again next week.
Thank you.
Ladies and gentlemen, I will invite you to be back, and we will continue this important discussion. It will be the fourth and final week of our series describing what this act is all about, called Free Exercise Religious Act in Idaho and other states that have been bringing that about. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station. Welcome to Public Forum, a community outreach program produced by North Idaho College located on Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guests.
I'm most pleased to welcome all of you back to our fourth and final week of a subject dealing with the law in Idaho, but it's also an issue in many other states and as well at the national level. In our case, it's the Idaho Free Exercise of Religious Act, and many people in our state are supporting it and many others are opposing it. On the first 2 weeks of this program, we had an opponent of the law, and last week we had a supporter, and he is back again this week. And we were very pleased to welcome back Robert L. Aldridge, who's an attorney in Boise. And I might add, he's in Boise, and we're in Coeur d'Alene. With this modern technology, we're able to tie in for this interview. We're appreciative to public television in Idaho for being assistance to us on this. Our guest holds a BA degree from the University of Idaho and a Doctor of Jurisprudence, or his law degree from Washington University in St. Louis, Missouri, received in 1970. He is admitted to practice law in the state of Idaho, as well as the Ninth Federal Circuit Court and the United States Court of Claims. Our guest is probably best known for his serving as co-attorney for the Boise JCs when they had what is called the Table Rock Cross case versus the ACLU, and he is in that capacity supporting the right to have the cross. He also has been involved in a number of other cases that versus the ACLU or the Humanist Association and other such organizations. Our guest is also very involved in historical preservation. He is a musician, and he also serves on a number of committees. Mr. Aldridge, it was nice having you last week, and thank you for coming back again this week so we can continue this very important and interesting subject.
Thank you.
And as always, I'm pleased to have our regular panelist, Steve Schenck, who is the Vice President of College Relations and Development at North Idaho College. And Steve will commence today's questioning.
Thank you, Tony. Hello, Mr. Aldridge. Nice to have you with us again. Last week, you did a wonderful job of taking us through the background of this issue and making a fairly complex issue very understandable. We don't want to just make this show a mirror of last week's show, but we also recognize that there are some people who are watching today who weren't with us last week, and I think it is important that they get a good background. Could you take us through that explanation again, please, but maybe shorten it a touch for us?
Sure. The local laws that have been coming into states now are based on a series of actions by the United States Supreme Court and Congress. In essence, back in 1990, the Supreme Court reversed a lot of years of precedent, if you look at it from my point of view, or by opponents' point of view, finally recognized some truth and said that religious freedoms don't have the same protection as other fundamental freedoms, such as freedom of speech and such. That was the Smith case out of Oregon. As a result of that, the National RFRA was passed essentially unanimously, co-sponsored by such people as Orrin Hatch and Ted Kennedy, and with the support of a huge number of organizations. That was passed through Congress, unanimously became law, and was in place until 1997. In 1997, the U.S. Supreme Court in the Bernie case out of Texas said that the RFRA standards, as they were attempted by Congress to place law within the states, was unconstitutional in that limited part. And basically, Congress could not tell the states what to do there. The states had to do their own statutes or have their own constitutional provisions. And so the states, as a result of that, have been adopting, some 18 to 20 of them now, and perhaps more as we now speak, have adopted local state RFRAs or Free Exercise of Religion Acts. to bring back up what was the original standard prior to all these series of cases, which is that for any governmental action to impact substantially a religious act or belief or practice, there has to be a compelling state interest, and the means used has to be the least restrictive way of carrying all of that out. So that's the history of what led us to where we are.
Thank you very much. Could you take us through just a little bit of history of what's happened now in states across the country regarding free exercise of religion? How many states, for instance, have adopted acts similar to the one adopted by Idaho?
Again, there's about 18 to 20 of them. Some states already had very similar constitutional provisions or other provisions still in place, so they weren't adopting new acts, they already had them there. But at least 20 and probably more now have these kind of things in place. We checked with all of these states, number one, before we adopted the act, so back prior to the the year 2000 legislation, and then again right before the effective date at the beginning of this year, end of last year. And in all of those states, what they said uniformly and unanimously was that, number one, there had been no problems whatsoever, that the acts had gone very smoothly, there had not been any of the problems that had been trumpeted here in Idaho as automatically occurring, and that, in fact, generally outside the state of California, where there was a dispute between the governor and the legislature over the bill, there had not been any particular amount of opposition or dispute at the time the bills were adopted or thereafter.
And again, Mr. Aldridge, last week we talked a little bit about the some states' rights issues and the fact that there isn't a uniform national free exercise of religion act. How much disparity is there between the states' different bills in this area? Or are they all pretty similar?
The bills themselves tend to be pretty similar. All of them are trying to do essentially the same thing, which is restore that two-part test that had been in constitutional law for so long as to fundamental freedoms, the compelling government interest, least restrictive means. In addition to that, Congress last year did adopt, and President Clinton signed into law September 13th of last year, the Religious Land Use and Institutionalized Persons Act, which again goes back to a federal standard in those two areas. Institutionalized persons covering not only people in prison, but also people in nursing homes and similar areas. So contrary to what happened at the time we originally adopted this in Idaho, there's again now a national standard on a lot of the areas that were problems.
And Tony, if you'll allow me one more quick backgrounding question for Mr. Aldridge, could you sort of put things in even more layman terms and tell us some of the problems that the Idaho legislation and other similar legislation are designed to correct?
The types of problems are when, especially a statute, ordinance, regulation, whatever, and especially again by local authorities, tends to, especially indirectly, as opposed to directly, inhibit the actual exercise of some religious freedom. Often it's an unintended result. For example, there have been cases where local high schools or athletic associations have said you can't wear caps when you're playing basketball. That's something that was designed to get rid of gang situation. It was also a safety issue. Somebody might step on a cap and slip. However, that had the unintended effect of saying that if you had Orthodox Jewish people that wanted to play basketball, they couldn't play. They had to wear their yarmulkes, and they couldn't do that. So those types of things would happen. Another example came out of California during the time that RFRA was in effect nationally, where the Colossus Sikhs, as a religion, who are a growing number of people in California, believed that at a certain age, if you are a member of the church, you have to carry a ceremonial dagger. Well, this was early enough that a lot of those kids were in school. Well, you have an automatic conflict now between the right of the school and the need of the school to protect students and not have dangerous weapons and so forth, but the religious need to have the ceremonial dagger. To give you an example of how RFRA worked, in that particular case, when that came to court, the judge forged the following decision. One, yes, you could carry the dagger, but it had to be literally as dull as a bread knife or duller. And number two, had to be sewn inside the scabbard and completely covered in a way that you could not get at it in anything less than an hour or so. Number three, it had to be hidden, had to be underneath your clothes. And there was no religious belief that it had to be displayed, it just had to be carried. This gave protection on both sides. The Colossus Sikhs got to carry their ceremonial dagger, but on the other hand, there was no danger to other school children nor to the school system. So RFRA is an attempt to bring all these back and say, let's serve both sides. Keep these protections in place that need to be there, but at the same time allow religious expression to the extent we can.
Thank you very much.
Mr. Aldridge, I'm going to go along that line also. The opponents to this legislation in Idaho who have appeared on this program, and also they as you do. They speak publicly around the state. I'm going to give you some examples of their opposition and let you respond, if you would, please. One that I've heard most often is that they have the interpretation of this law that if someone was to physically abuse a child, a parent, through using the rod, or whatever, and they would quote from certain biblical passages that spare the rod and spoil the child. They were concerned about child abuse questions. How would this law address that issue? And I just want to give you the chance to respond to their criticism.
Sure. At the time we were debating this in the Idaho legislature, the opponents came up with a list of 1,300 cases in which they said that someone had been accused of child abuse and had alleged some kind of religious defense to that. We looked at those cases and found out, lo and behold, in all 1,300 of those, the person was in fact convicted. So if there is legitimate child abuse, that's always going to be a compelling governmental interest, and you're not going to be able to hurt somebody else in the name of religion and get away from it. What the debate has been is the difference between, say, spanking a child, legitimate discipline, and when does that cross over into abuse. That's always been a difficult area to address. But the RFRA courts have handled this well. The courts in the United States have handled this well for a lot of years. We simply don't have a history. Remember also that RFRA was in effect for essentially 30 years, either indirectly because of those standards being the case, from and after, Wisconsin v. Yoder, the Sherbert, the Werner cases, all of those cases, up through the adoption of RFRA, and then now that we've got back into the states holding them. So we have about 30 years of history with those exact standards in place. There have not been any horror stories about abuse being allowed in the name of religion. Simply not there.
Thank you. My second example would be on planning. And again, that's one of your areas of expertise in zoning. You gave the example of it on our last show last week of a city where, because of the restricted zoning ordinances, there could only be 4 churches within the city. There could not be any others built. Let's reverse that from, on the other side of the coin, from your opponents. And an example I heard given by them is that suppose there was a proposal for a zone change and it was a religious organization, but someone who lived in that neighborhood came forth with a different particular religious belief to say that their religious belief would be infringed upon by having that zone change for the expansion or development of religion. How would this law affect in those situations?
Well, this law would affect that not at all, since you now have the religious land use bill nationally in effect that has that exact set of questions that it covers. So that's been preempted out. This statute wouldn't cover that at all.
Okay. Thank you. And then the third example that I have has to do with, it seemed like it was 5 or 6 years ago in Florida. And I know that the history of the U.S. Supreme Court in trying to define religion, that is also another great challenge. We have complexities in our society that, and you've given some of those today, that are very, very challenging. But a group got together and created a new religion, a new church. And I believe I'm correct that the court also looks at historical, how long a church has been, or a religion, I should say, an organized religion, has been in existence and tradition. But they created a new church and said they would meet each week, and at their services they would have communion, but it would be hard drugs, such as cocaine. Mm-hmm. And they lost in court because it was looked at as a way of avoiding, I guess, what we call a compelling state interest to protect against hard drugs. If they attempted that in a state such as ours under this new law, how would that be addressed?
Again, I think that the opponents of this bill don't have as much faith in the court systems as I do. To begin with, we've got a long history. The IRS, for example, has dealt for an awful lot of years with what's a church and what's not, because there's an automatic advantage tax-wise to being a nonprofit and especially a 501c3. And so they've done an excellent job over the years of defining here's what makes a church and what all the things that have to happen, who's a minister, all those sorts of things. So to begin with, there's a lot of law in place that can be used in the background. In addition to that, remember that the Free Exercise of Religion Act does not say that if you say, I've got a religious belief, then the state just folds up its books and goes away. All it says is that, number one, if you have come forward and met the burden of saying this is a substantial impairment on my ability, it's a burden and it's substantial, not just incidental, then the state only has to show, A, there was a compelling state interest. That's almost always going to be the case. Zoning, child abuse, voting rights, any kinds of preferences of that sort are always going to be a compelling state interest and have always been so held. And then number two, the court's going to look at, are there alternate ways to do this? If this is the only way to do it, the religion loses because the state can carry out that compelling state interest. If there are alternate ways, are they available? Are they really there? Are they practical? And if so, can this be switched to a different method and accommodate both? So you go through a lot of situation before you ever get to the point of this being declared. Remember also that there seems to be a feeling that this is just going to be used willy-nilly. If you're going to do this, if you're going to allege this religious defense, you're going to go through a long period of court battles, perhaps arrest, certainly a lot of time, expense, and emotional turmoil. So it's not something people are going to take on just easily and quickly, just to have some fun. So I think that's another thing, is that these types of things will be thrashed out, by and large, only when they're real. The people that you were talking about that are saying we have a sudden religious belief that we can use hard drugs, or that I have a sudden religious belief I can drive 100 miles an hour the wrong way down freeways, are going to be filtered out very rapidly by the court system.
Thank you. And one final one before I go back to Steve. We've had an unfair image. It's just totally unfair to Idaho, and you know what I'm speaking to, and that was the Aryan Nations. And of course, that lawsuit last year was won by the Keenans, and that compound does not exist, but they had the Church of Jesus Christ Christian. And again, the opponents have referred to this sometimes, that could an organization like that use their religious doctrine to engage in some form of activity that comes under the category of hate and harassment?
Let's go through a couple situations. At the same time that the ACLU was opposing this in the Idaho Senate hearings, they made some statement about if we do this, the Aryan Nations will be able to march in the streets. Well, I reminded them that the ACLU had just gone to court up in Coeur d'Alene to protect the rights of the Aryan Nations to march in the streets. There's a big difference between saying we can get out our message. Again, the idea of religious thought and religious speech. But there's a huge ability of the state to clamp down on religious conduct. And there has never been a case where, in any case I'm ever aware of, where they said there's a religious right to go shoot people, where there's a religious right to beat people, where there's a religious right to go out and discriminate, especially on the basis of race. Those have simply not been upheld. So is the Aryan Nations going to be able to use this in some way that's damaging to Idaho? No.
Thank you. Steve Sheen.
Mr. Aldridge, I'm curious, in the 18 or 20 other states that have adopted legislation similar to Idaho's, has there been an increase in legal activity or any particularly troublesome lawsuits brought?
Neither in those states since the state RFRAs were adopted, nor in the United States as a whole during the time that the national RFRA was in place. For example, in Idaho, during those number of years while the state was under the federal RFRA standards, we found out that in the federal prison system, for example, in the state prison system that was here, there was less than 1/100% of the cases that even mentioned RFRA. None of them in which RFRA was used to overturn anything that had happened in the prison system. So we didn't see this rush to the courts that the opponents keep bringing up. It simply hasn't happened.
And on the opposite side of that coin, I think I'm gathering from what you've already told us that there wasn't any chilling effect in this particular legislation. In other words, RFRA doesn't inhibit the ability of people who legitimately feel that their rights are being violated to litigate.
Absolutely true. It makes sure that when you go to court, you're on a level playing field. What had happened from the Supreme Court decisions was that you had religious freedom here, but freedom of expression, of speech, and so forth up here. It simply says if you're going to be in court, level playing field. That's all we ever ask for. The opponents, I assume, have probably said, perhaps on this show, certainly in the debates we've had, that somehow this elevates religious freedom above others. It does not. All it says is you have the same standards that you have if you have any fundamental freedom.
And Mr. Aldridge, you may have some hesitancy to do this, but I am sort of curious, and maybe you would like to comment. 18 or 20 other states have passed similar legislation without a great deal of difficulty, perhaps without any difficulty. And yet, I gathered from some of Tony's questions and statements in our last show that in Idaho there seems to be some organized opposition to the newly passed bill. Can you comment on, in your opinion, why that is the case here?
I have been told that on the national level, the reason for the ACLU's pullout from the coalition in favor of whether national or local laws of this sort has been basically over the area of gay rights. And they feel that if these standards are in place, that gay rights in the area of perhaps homosexual marriage, whatever, may not be able to be brought in as fully as they would without these standards in place. I can't tell you on the local level whether that facts is what is driving it or not, but certainly it has been brought up a lot in the debates we've had. A lot of the discussion has been about, well, if we do this, then you'll be able to discriminate on the basis of sexual orientation and hiring, etc. The answer to that is that, number one, all of those hiring and similar decisions are federal law. Those aren't covered by the state RFRA. And number two, neither the national government nor the state of Idaho has ever said sexual orientation is a protected minority status, unlike race and sex and age and some of those things. It has never been held to be such. It's not a protected status. So individuals can have religious beliefs about those situations, and they are not violating federal law, nor would they be violating state law if there was an area in which that occurred without the overriding federal standards in place.
Thank you very much.
Just one quick follow-up question on that. Protected groups such as race, color, and gender and so forth, if there is a protected class added to that at the national level, then this law would not interfere with that in any way?
No, again, you'd be back to saying there's this overriding federal legislation that preempts.
Right.
For example, you couldn't have the state of Alabama, Mississippi, whatever, saying that regardless of what the voting rights say and the Civil Rights Act of 1964 and such, that in the state here, you were allowed to discriminate on race, and you can have, again, back to colored versus white bathrooms, that kind of stuff. It simply would not be allowed. That's very clear under constitutional law.
Under protected classes.
Mm-hmm.
Another issue that's come up by the opponents to the law in the state of Idaho is that they interpret the law to be that it creates two classes of people, and that for those who are religious, that they have a different kind of protection than the residents of the state that are non-religious. Would you respond to their criticism?
Certainly. What had happened, in fact, was the direct opposite. If I said, here is my belief, and I'm just saying it, and I don't have any religious standards behind it, I had the freedom of expression, freedom of speech clear up here. If I said, and by the way, it's religious belief, all of a sudden, boom, down drop my rights and my protections to a lower standard. This simply brings those back up level. So no, it took what was a two-tier system, with religious people being discriminated against in terms of their ability to carry out their beliefs, and brought it back to a level playing field.
In relation to that, and on both programs, when you've been talking about certain constitutional questions, would you take a minute to talk about the First Amendment with us? And as one becomes a student of the First Amendment, one sees that there are two religious clauses, and the significance is that it's at the very beginning of the First Amendment. And from your viewpoint as an attorney and someone who's had a lot of cases in this area, would you define for us the difference as you see it between the clause we call the exercise clause, free religious exercise, and no establishment clause? The founding authors had some purpose in putting both of those clauses in the First Amendment.
Certainly. If you remember the history of the United States, in the early colonies, a lot of those colonies had official state churches. Maryland was Catholic, and some had congregational, some had others, Church of England and so forth. And so there was a great fear that there would be some kind of an official national church that could compel perhaps membership, that could compel tithing and so forth, as is the case in some nations still. And so there was a great feeling that we need to make sure there was no national church. We could be a religious person. We could have religious organizations that were very prominent, but we didn't have a single religious denomination that was preferred above others. And so, for example, when the letter in 1802 from Thomas Jefferson to the Danbury Baptist Association is often quoted, where the first phrase was used of this wall between church and state, that was a response to a letter that the Danbury Baptist Association had sent to President Jefferson saying, we are afraid that there's going to be the establishment of a national church, and it isn't going to be us, it's going to be a different religion. And the right back of the letter said, no, there is a wall separation. The government is not going to impose on you this religious, in essence, approved church that's going to be the national church. That was where that phrase came from. It was not something saying that you are not allowed as a church to impact society. Direct opposite was the case in those days especially. But I think that is where there's a lot of misunderstanding of this. The Establishment Clause doesn't say that religion can't affect society, can't affect government. It obviously has and will continue to do so. But what it says is the government cannot impose on the people this form of belief by saying here's the official either set of beliefs or the actual church that carries them out. That's the Establishment Clause. The Free Exercise Clause says that, on the other hand, the government is not to allow any inhibitions on the free exercise of religion. It's not to impose those. Obviously, that's a statement that's easier to make than to actually carry out. And that's where the thrashing about has been in all the law cases, is where are those limits? There are obviously some. The old tried example of yelling fire in a crowded theater says that there are limits on what you can do in terms of public speech and its resultant actions that come with that. And so we've had a lot of case law, but that's the nature of law. It becomes more and more complex as we go because, number one, as attorneys, we're very good at finding all the little ways to go around the edges. And so the courts have had to say, okay, here's some lines, and now when you find ways to go around those lines, here's some new lines to keep you back in the boundaries. Also, as I think we discussed last show, we tend to be a society that swings the pendulum from one far side to the other far side. We seem to have a hard time stopping it in the middle and saying, here's a good balance. We tend to be all one or all the other, and the courts in the 60s, I think, went the pendulum quite far. They were very activist in terms of saying, let's remove, in essence, religion from society. That went too far. I think there's been a reaction to that. The pendulum was coming back to the middle. The question is, will it stop here in the middle, or will it swing too far? And I think that what the fear is, perhaps, on some of the opponents is not where the pendulum is right now, nor where this statute in Idaho would put it, but that somehow this is going to be just a start of something new. And that the next thing will happen is that we will have new legislation that will add to this, that will impose various standards on people or prescribe religious beliefs, etc. I don't see that happening, but I would think that that's probably the fear that they're saying. My answer to that is obviously, let's stop that, not this law. This law is correct. We're getting back to the middle. And the legislators that have been involved in this have been very clear. If there is any problem with this statute as it now sits, they will change it. They will react to that. And that's been unanimously said by all of the sponsors in the Senate and the House, and certainly it's something that I'm very committed to. I've been down to the legislature now for 10, 12 years, doing a lot of different legislation, primarily in the area of tax and elderly rights and so forth. And one of the things I've always held is that if there's a problem crops up, we come back and fix it. I think that's what will happen here as well.
We're just about out of time, but what you're also saying about all of our discussions the last 2 weeks, that there obviously will be disagreements and disputes, and if there's a particular case where there's a concern, it can go to court, and the courts can see in that particular case if it is a religious question or if it's an attempt to abuse the rights of someone.
Again, I have a lot of faith in the court system here in Idaho. We haven't seen some of the real strange types of decisions that some states have been plagued with on occasion. California probably gets overemphasized on that, but it certainly has had some interesting cases over the years. That hasn't happened here in Idaho. I think that Idaho judges, by and large, are rational, balanced, and I think they tend to reflect their local community. And so I have a lot of faith in that.
On that note, I'll have to bring our program conclusion. Robert Aldridge, we thank you so much for being with us 2 weeks. It's been most informative, and we're ending a 4-week series hearing from both sides. Thank you for your time, and you've been generous with your time.
Thank you for having me.
And Steve Shink, thank you so much for your questions today. And ladies and gentlemen, I would like to invite you to be with us again next week when we will move to another issue. In fact, we're going to start a long series dealing with Chautauqua performance of interviewing people from history. It's a very famous format and a very popular format, and we'll have some famous people from the past being played by scholars today, and I hope you'll join us. And that series will last for about 10 weeks, and it'll be a great variety of people dealing with issues on the human spirit and people from history. And we invite you to write to us from time to time about your questions, and we'll respond with you. Until next week, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running entirely college-produced program on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us again at this same time next week for another edition of Public Forum on this public television station.
That's scary.